Intro. When the HOA came knocking at my door, demanding I remove my dock, they had no idea they were picking a fight they couldn't win. What started as a petty neighborhood dispute turned into a battle over power, property rights, and control. But what they didn't know was that I hold the cards, and every waterway in this county flows through my hands. The first time I saw the HOA representatives marching up to my property, clipboards in hand and a look of self-importance plastered on their faces, I knew they weren't coming over for a friendly chat. I was sitting out on the dock that morning, enjoying the peaceful sound of water lapping against the wooden posts, when I noticed them approaching from the street. Their stiff posture and quick pace told me they were on a mission, and as soon as they got close enough, the lead representative cleared his throat with an exaggerated sense of authority. He didn't even bother with pleasantries, no good morning or how's your day. Just a blunt declaration that my dock was in violation of community standards and that I needed to remove it immediately. I raised an eyebrow, partly amused, partly annoyed, because this dock had been here long before I ever moved in, and as far as I knew, it was well within my property rights. But the way they stood there, looking at me like I was a defiant child who needed correcting, made my blood boil just a little. They pulled out papers with highlighted sections from the HOA bylaws, pointing to clauses about unauthorized structures and encroachments on shared community property. I listened without interrupting, trying to make sense of why they thought they had any say over my dock. The more they talked, the clearer it became that they were convinced they had absolute authority over everything in sight, even the water itself. I glanced past them to the calm, glistening lake that stretched out behind me, the same lake that connected to streams, creeks, and smaller waterways across the entire county. Their ignorance about who actually had jurisdiction here was almost laughable, but I let them keep talking. They mentioned fines, deadlines, and further action if I didn't comply. I could see they were expecting me to either get defensive or beg for an exception, but I wasn't about to give them the satisfaction. Instead, I calmly asked them a few questions about the basis of their claim, and their answers were vague at best. They spoke in circles, repeating community property, without ever explaining how my dock, built on land I legally owned, fell under that category. Their confidence seemed to falter just slightly when I asked if they'd ever reviewed the county's property records or the original land deeds for the area. One of them glanced at another, almost like they weren't sure. In that moment, I realized they were operating entirely on assumption and the belief that everyone would simply comply because that's what the HOA says. The sun glinted off the water behind me, casting a reflection that almost made the dock glow, as if silently backing me up in this standoff. I could feel the tension rising in the air, their frustration growing as I refused to give them a straight yes to their demands. They shifted their tactics, warning me about setting a bad precedent for the neighborhood, and claiming that other residents were upset about my dock being there. I doubted that was true. No one had ever complained to me before, but it was clear they were trying to pile on social pressure to make me fold. I stayed seated, leaning back slightly in my chair, letting them throw out every reason they could think of. The whole time I was making mental notes, not just about their arguments but about the way they avoided giving any concrete evidence to support their position. To them, this was just another routine enforcement, a show of power to remind residents who was in charge. What they didn't know was that they had just stepped into territory where their rules didn't apply. After the HOA's little performance on my dock, I decided the next step was to take a closer look at exactly what they were claiming and how it stacked up against the actual law. That meant digging into my property records, land deeds, and any relevant county documents to get a crystal clear understanding of where my rights began and ended. I've always been a stickler for knowing the fine print before making a move, and in this case it wasn't just about keeping my dock. It was about making sure I understood the full scope of my position before I even considered responding to them. I started by pulling out the deed to my property, the same one I received when I bought the place. It clearly outlined the boundaries, listing not just the land but also specific water access rights. These weren't vague "you can walk to the water" rights either. They were explicitly tied to ownership, with descriptions dating back decades that referenced exclusive access and use of the adjoining shoreline. The dock itself was mentioned in the original survey, meaning it had been recognized as part of the property long before I ever showed up. That alone already made the HOA's claim look shaky, but I wasn't stopping there. I went down to the county records office to see if there was anything else in the historical files that could clarify the situation. I found maps, surveys, and legal documents showing how the waterways were divided and controlled over time. What really caught my attention was a series of old legal agreements between the county and various property owners along the lakes and streams. These agreements laid out water rights in no uncertain terms, specifying exactly who could build structures, maintain access, and control certain sections. My property, and specifically the dock area, was included in one of those original agreements. As I read through them, it became clear that the HOA wasn't just overstepping. They had no legal standing to interfere with my dock at all. The lake and its connected waterways weren't community property under their jurisdiction. They were considered part of a network of navigable waters that fell under a completely different set of regulations, none of which gave the HOA any authority. The more I learned, the more obvious it became that they hadn't done any homework before confronting me. It was almost as if they assumed that because my home was within the boundaries of their community, everything I touched had to be under their control. The reality was far more complicated, and I was starting to see just how much leverage that complexity could give me. While flipping through the records, I also came across an interesting detail. Certain easements and rights-of-way gave me not just usage rights to the water directly in front of my property, but also indirect control over several feeder streams that connected to the main lake. That meant if someone wanted to make changes upstream or downstream, there was a chance they'd need my approval. The implications of that were starting to take shape in my mind. Back at home, I reviewed the HOA's bylaws and covenants line by line, comparing them against the official legal records. It was almost laughable how weak their position was when put side by side with the actual county documents. They talked a big game about protecting the community's aesthetic and ensuring uniformity, but none of it applied to my dock. Every reference they made to shared space fell apart when measured against the legal boundaries in black and white. It was becoming clear to me that they relied more on intimidation and residents not knowing their rights than on any real authority. And while they were busy waving around their clipboard rules, I was quietly building a rock-solid case based on facts they couldn't dispute. The more I dug, the more confident I became that I wasn't just going to win this argument. I was going to turn it into something much bigger. The deeper I went into the records, the more fascinating the story of these waterways became. It wasn't just about my dock anymore. This was about a piece of history that had been quietly preserved in legal language for generations. Buried in the archives was the revelation that my property came with something far more powerful than ordinary shoreline access. Decades ago, long before any HOA existed in this area, a large section of interconnected waterways had been placed under private stewardship. The original owner of my land wasn't just a homeowner. They were a land baron of sorts, with documented water rights that covered the entire network of streams, inlets, and channels branching out across the county. These weren't symbolic rights either. They came with the legal authority to approve or deny alterations, construction, and even access in some areas. When I purchased the property, those rights were transferred to me automatically as part of the deed, but like most people, I didn't think much about them at the time. Now, standing in the middle of this conflict, their significance hit me like a tidal wave. The legal language was precise and ironclad. I had the authority to maintain, restrict, or permit usage of these waterways within the specified boundaries, and those boundaries weren't small. I was staring at a network that stretched far beyond my immediate property, touching dozens of other parcels of land, many of which were within the HOA's own map. It explained why, in some cases, past owners of my property had been consulted before anyone built a dock, dredged a channel, or made modifications along certain shores. The HOA either didn't know about this history or had chosen to ignore it, assuming no one would ever call them out on it. The thought was both infuriating and a little amusing because they had walked right into a fight with someone who, on paper, outranked them in this particular arena. As I traced the map of waterways on the old survey, I could see just how extensive the network was. Streams that wound through wooded areas, quiet coves tucked behind private lots, even small tributaries that fed into public recreation areas. All of them were part of the system I now controlled. It wasn't a matter of me owning the water itself, but rather holding the rights to its usage and alterations, a distinction that carried tremendous weight in legal disputes. In practical terms, this meant that if the HOA wanted to so much as adjust a shoreline landscaping project that touched any of these waters, they would need to seek permission from me or risk violating county ordinances. I could feel a shift in my mindset as the reality settled in. This wasn't just about defending my dock anymore. It was about understanding and asserting a position of authority I had unknowingly held for years. I thought back to the way the HOA representatives had stood there on my property, puffed up with the belief that their binder of rules made them the ultimate authority. I pictured the look on their faces when they realized the truth. They had stormed in to demand the removal of a dock from the one person in the entire county who could legally control whether they had docks at all. There was a certain poetic justice in that, and I couldn't help but appreciate it. But beyond the satisfaction, I knew this revelation came with responsibility. These waterways connected to countless residents' lives, fishing spots, boat routes, scenic views. It wasn't just a technicality. It was a real influence over the community's daily enjoyment of the land and water. Holding that kind of control meant I needed to be deliberate about my next move. I couldn't just drop the news on them without preparation. I had to think strategically, gather more supporting documentation, and maybe even consult with a legal expert to confirm the full extent of my rights before bringing this to the HOA's attention. When I compared the actual scope of my rights to the HOA's demands, the gap between their perceived authority and the legal reality was massive. They had walked onto my property and tried to enforce a rule that had no connection to any legitimate power they held. And the more I examined their position, the more it became obvious they were operating outside their jurisdiction entirely. The lake and waterways they were claiming as community property were not, by any stretch, under their governance. In fact, the HOA's official map of managed areas stopped well short of the shoreline in question. The bylaws they carried around like gospel were written to cover shared amenities such as clubhouses, parks, and internal neighborhood landscaping. Nowhere did they mention regulating privately owned docks on waterways governed by county and state law. That alone should have been enough to shut down their case. But their overreach wasn't just a misunderstanding. It was a pattern. As I began talking to a few neighbors, I learned I wasn't the first person they had tried this with. The HOA had a habit of testing the limits of their authority, hoping that most residents wouldn't push back. For some, it was easier to comply than to challenge them, especially when faced with the threat of escalating fines. That was their real weapon, not legitimate power, but intimidation through process and persistence. This time, though, they had chosen the wrong target. I had the paperwork, the history, and the patience to see this through, and they had no idea how much ground they were about to lose. In their initial visit, they had implied that the dock was obstructing shared views, and that the water in front of my home was for the enjoyment of all residents. That language might sound persuasive to someone unfamiliar with property law, but it crumbled under scrutiny. The concept of shared enjoyment only applied to designated common areas, and my shoreline wasn't one of them. It was clear that they were trying to stretch the interpretation of their own bylaws to fit a narrative that benefited their control. The irony was almost comical. They were attempting to regulate something that, under county records, they would actually need my permission to touch. I thought about the way they had presented themselves that day, standing at the edge of my dock with their clipboards and serious expressions, certain they had the final say. I could already imagine how quickly that confidence would fade when confronted with the documented proof that they were the ones encroaching on my rights, not the other way around. But even as I pieced together their lack of jurisdiction, I kept my expression neutral whenever I ran into any of them around the neighborhood. I didn't want them to know how much information I had gathered or how solid my case had become. The advantage was mine, and part of holding that advantage meant keeping them in the dark until the timing was right. There was also a deeper satisfaction in knowing that their attempt to pressure me had backfired in the worst possible way for them. Instead of quietly removing the dock, I now had every reason to bring their overreach into question, not just for my own benefit but for other residents who might have been misled or coerced in the past. I could already see the potential ripple effects of exposing this. The HOA would have to rethink how they operated, and they might even face challenges from multiple homeowners once word got out. The situation had shifted entirely from them holding the upper hand to them being in a position where they would have to answer for their actions, and I was in no rush to let them off easy. Walking into the county records office with all my notes in hand, I already suspected what I was going to find, but seeing it confirmed in black and white was something else entirely. The official property maps, historical agreements, and legal annotations didn't just support my case. They cemented it beyond argument. There it was, stamped and signed in multiple records over the decades. I held the controlling rights to these waterways, and those rights had never been transferred, sold, or diminished in any legal capacity. The language wasn't vague or open to interpretation. It was explicit, stating that the owner of my property retained authority over construction, alteration, and maintenance of any docks, piers, or similar structures on connected waterways. And because the lake was connected to a series of streams and inlets throughout the county, that authority extended far beyond the HOA's reach. I took my time making certified copies of everything, ensuring I had both digital and physical backups. I wanted to be ready for whatever the HOA might try next, and I knew that having these documents in hand would be my best defense against their posturing. On my way out, I spoke briefly with a clerk who'd been working there for years, and she confirmed something I'd already suspected. The HOA had no standing whatsoever in matters involving these waterways. She even hinted that this wasn't the first time someone had come in asking about disputes between the HOA and waterfront property owners, but in every case, the law was on the side of the deed holder, not the association. That small confirmation added another layer of confidence to my position. Back at home, I laid everything out on my desk, the maps, the deeds, the historical agreements, and studied them like pieces of a puzzle. It was one thing to know I had the upper hand. It was another to fully grasp just how much leverage I actually held. With control over these waterways, I could dictate terms, approve or deny any future construction projects, and potentially even influence recreational use in certain areas. It wasn't a power I ever anticipated having, but now that I understood it, I realized just how valuable it could be. From a strategic standpoint, this meant that the HOA couldn't make a single meaningful move involving the lake without my consent. They couldn't legally enforce removals, build new structures, or alter existing ones without stepping into a legal minefield. And if they tried, I had more than enough documentation to take the matter directly to the county or even into court, where they would almost certainly lose. As I sifted through the records, I also found old correspondence between previous property owners and the county, discussing approvals for minor dock repairs and maintenance. Every single one of those letters was addressed directly to the title holder of my property, bypassing any mention of the HOA entirely. That told me the system had been in place for decades, functioning without interference from any local association. If the HOA had done even a minimal amount of research before confronting me, they would have known they had no authority here. Instead, they'd walked straight into a fight they were destined to lose. That realization made me even more determined to see this through. This wasn't just about keeping my dock anymore. It was about standing up to an organization that thrived on residents' ignorance and fear. By bringing the truth to light, I could not only protect my own property but potentially shield others from future harassment. And knowing that every official record, every historical agreement, and every county map backed me up made it all the more satisfying to prepare for whatever they might throw my way next. Armed with the knowledge and documentation confirming my authority over the waterways, I began to think about how to approach the HOA from a position of undeniable strength. This wasn't going to be a shouting match on my lawn or a back and forth over vague bylaws. If I was going to shut this down, I wanted to do it in a way that left no room for argument, no opportunity for them to twist the facts, and no doubt about where the real authority lay. My first step was organizing the evidence into a clean, chronological package, starting with the original land deeds and water rights agreements, moving through the historical maps, and ending with the current county records. I highlighted the key sections in each document, making it impossible for anyone to miss the parts that spelled out my control in plain language. I also included certified copies of everything, so even if they tried to dismiss my personal copies, the official stamps and signatures from the county clerk's office would stand as irrefutable proof. Once that was in order, I drafted a letter that was firm but professional. I laid out the facts clearly, the history of the property, the legal standing of the waterways, and the complete lack of HOA jurisdiction over them. I avoided emotional language or accusations. Instead, I let the documents speak for themselves. The letter concluded with a simple statement that any further attempts to enforce HOA rules on my dock or the connected waterways would be met with immediate legal action supported by the county's own records. With everything prepared, I considered how best to deliver it. A casual drop-off at their office seemed too informal for the weight of what I was presenting, and an email could be ignored or deleted without acknowledgement. In the end, I opted for a formal delivery via certified mail, ensuring they would have to sign for it and that I'd have a record of them receiving it. That way, there could be no claim later that they hadn't been informed. While waiting for the delivery confirmation, I kept my usual routine around the dock, acting as though nothing had changed. But inside, I knew the power dynamic had shifted completely. The HOA might have started this believing they could intimidate me into compliance, but now they were about to realize they had overplayed their hand in the worst possible way. I also couldn't help but think ahead to the inevitable meeting or conversation that would follow once they read the letter and saw the documents. Their options would be limited. They could either back down quietly, hoping to save face, or they could try to push forward, in which case they would be walking directly into a legal trap. Either way, the outcome would favor me. Beyond just defending my own property, this moment carried the potential to redefine how the HOA interacted with every waterfront property owner in the community. If they backed off, it would send a message that their authority had limits, and that those limits could be enforced by anyone willing to stand their ground. And if they challenged me and lost, it would be a public and humiliating defeat that might discourage future overreach. Knowing I had that kind of influence made me realize that this fight, as irritating as it had been at the start, was an opportunity disguised as a conflict. What began as a demand to tear down my dock had evolved into a chance to draw a line in the sand, or in this case, the water, that they would think twice about crossing again.